The next case to come before the court is in re TM. Each party will have up to 15 minutes to present your arguments. The appellant may reserve up to 5 minutes for rebuttal. If you do plan to reserve time, please let me know as I'll be keeping track of the time. The arguments are being recorded, so please introduce yourself, stay behind the podium, and keep your voices up. You should not use the name of children or minors or victims during your argument. You can refer to them by initials or generic terms. The judges have read your briefs and we're ready to proceed when you are. I would just ask the appellant whether you would like to reserve time.
Yes, may I reserve 3 minutes for rebuttal?
Certainly.
Your Honors, may it please the Court. My name is Victoria Ferry, and I am here today representing the appellant, TM, in this case. TM respectfully asks this Court to reverse the juvenile court's decisions for 3 reasons. The first, TM was not serving the juvenile portion of her SYO sentence. She was never actually on probation, never assigned a probation officer, was never given probation roles, and never met with anyone from the probation department. Further, there was no clear and convincing evidence that TM engaged in conduct that created a substantial risk to her community, or that she was unlikely to be rehabilitated by her 21st birthday. The second, with the lack of an impartial decision maker, TM's due process rights were violated at her invocation hearing. And last, the procedures set forth under Revised Code 22CA011868 failed to adequately protect the liberty interest by 1, destroying the character and integrity of the adversarial process, and 2, forcing the judge to form a judicially acquired bias when bringing its own motion. Before addressing the assignments of error, it must be noted that the state's arguments were never properly preserved and therefore are not proper before the court today. The bottom line is that prior to this appeal, the state was in agreement with the defense. There was not clear and convincing evidence. The state refused to present any evidence or provide recommendation to the court at the invocation hearing. Now, the state stands here today and argues the record contains clear and convincing evidence. Not only does this run completely contrary to the statements made on the record, but has not been properly preserved before this court. This court does not consider arguments raised for the first time at this stage of the proceedings. As such, this issue is not properly before the court. In our first assignment of error, we argue that the lower court erred when it invoked TM's adult sentence because it lacked statutory authority to do so. Under Revised Code 215214, the court may only invoke a child's adult sentence of an SYO if it finds by, again, clear and convincing evidence all of the following: that the child is serving the juvenile portion of the SYO sentence, is at least 14 years old, has either been admitted to the Department of Youth Services or has criminal charges pending against them, and last, has engaged in misconduct that creates a substantial risk to the community, and that misconduct demonstrates that the child is unlikely to be rehabilitated during the remainder period of the juvenile court's jurisdiction. Here, again, TM was not serving the juvenile portion of her SYO sentence. After her file was sent to the Cuyahoga County, staff at the Lorain County Juvenile Probation Department contacted the Cuyahoga Probation Departments 4 separate times to inquire about the status of the transfer. Each time the staff member called, Cuyahoga County informed them that no probation officer had been assigned to TM. Further, TM's mother confirmed that, again, she had not talked to anyone at this Cuyahoga Probation Department. Finally, on December 28, 2021, the administrative judge of the Cuyahoga County Juvenile Court contacted the Lorain County Probation Department, informing them that Cuyahoga County was again rejecting this transfer. TM was not actually on community control. Again, she was never assigned a probation officer, never signed paperwork, and she never checked in with anyone.
No one in the court here after Cuyahoga County said they would not take the case. Did the court here in Lorain issue any additional orders on the record?
No, Your Honor. This was exclusively with the Cuyahoga County Probation Department. And again, she did not speak with anyone about that specific case prior to the invocation hearing. And second, there was not clear and convincing evidence that TM engaged in behavior that created a substantial risk to the community. There are two sub-requirements to this prong. One, there must be clear and convincing evidence that TM actually engaged in misconduct. And two, that misconduct must have created a substantial risk to the community. Here, the only evidence put forth by the court in support of these requirements was that TM was facing charges in the juvenile adult courts in Cuyahoga County. Out of all the cases detailed again by an unsworn probation officer, there was only one where TM was actually adjudicated delinquent. For all the other cases, she was merely charged, not found guilty. She was facing charges that had not been found guilty in any of those cases. Thus, she was presumed innocent, and no misconduct could have been.
So your view would be that any pending charge, no matter how serious, what the offense is not going to be sufficient under this statute? That's only pending and not been adjudicated, not been decided.
Well, we recognize when you are bringing the motion, you need reasonable cause. And moving to actually being able to execute that under subsection E, you need reasonable cause. Again, I don't know where the line is, but here she was only indicted, and that only requires probable cause.
There was some evidence the judge heard, and you can debate that it's hearsay, but that she confessed to committing a murder and carjacking, I think, or at least a murder in this case. Didn't that sometimes just substantial risk to the community, if that was believed by the trial court, by clear and convincing evidence?
Again, this was by an unsworn probation officer and introducing evidence by someone.
When you say unsworn, it was there, so the court did not place anyone under oath when they took the testimony of the probation officer.
Yes, that is correct, Your Honor. And there was actually a pending motion to suppress at that time as well.
And did the court ever rule on that motion?
No, at that time it had not ruled on that motion.
Did it rule on it afterwards?
It did. So that case is also still under appeal.
Okay. There was a pending motion in the other, not in this case, in the case in Cuyahoga County, there was a motion suppressed.
That they were referring
Understood.
to, yes. And I would add to that, Your Honor, in the case in which she was before the Cuyahoga County, not the one they were referring to, they actually had labeled her as a very low risk to reoffend. So we would argue, again, if she was a substantial risk in the Cuyahoga County, they would not have deemed her as low risk and have not placed any additional orders. So this was on a separate case.
Is that in the record in this case where whatever Cuyahoga County did, was that admitted at the probation hearing?
On that,
In the invocation, what you're talking about, Cuyahoga County felt in their case she was low risk. Was that placed on the record in our case that we're looking at, or is that something outside the record you're telling me?
no, I believe he did mention that
Okay.
she was low risk. I believe that again I have that on page 14 of the May 5th.
Thank you.
Yes. So moving on to, there was not clear and convincing evidence that TM was unlikely to be rehabilitated by her 21st birthday. At the time, TM was only 18 years old and had 3 years left under the juvenile court's jurisdiction. The juvenile court made no findings about why 3 years would not be enough time. Further, the court made no findings about what rehabilitative efforts TM had tried and failed, because here there were no rehabilitative efforts undertaken by the juvenile court. There was not even an opportunity for TM to fail, and the court made no findings about why any further efforts would be of no use. Moving to my second assignment of error, the trial court erred when it acted as both prosecutor and tribunal at her invocation hearing. In this case, the judge went beyond serving as a fact finder and decision maker, but actually presented the case in favor of TM's invocation. To the confusion of counsel, the prosecution, in fact, never put on any case in favor of the invocation. All facts were provided through witnesses called by the judge or through the questioning of the prosecuting attorney themselves. Before its ruling, the judge stated that all parties had presented an oral argument regarding the court's motion. Again, this created a reasonable belief that impartiality was impaired. In this case, the judge was essentially serving in dual competing roles, acting as a prosecutor would, presenting evidence in favor of this invocation. Then, as judge, he served as the ultimate decision maker, ruling on objections to his own evidence and deciding whether to invoke TM's adult sentence. It is impossible for a judge to remain impartial here while serving these dual competing roles and actively arguing in favor of the invocation. With a lack of an impartial decision maker, TM's due process rights were violated at her invocation hearing.
And I appreciate you arguing this statute also is unconstitutional the way it's set up. But can you point to anything particular in the record? And this is an odd circumstance when we have a court bring its own motion and present it. Can you point to specific things in this record the judge did that shows prejudice to your client, TM?
I would argue his conduct throughout. I mean, he is actively presenting witnesses. At the time, the prosecution did not present any evidence or recommendations, and yet he proceeded to question the prosecutor.
But the statute seems to contemplate that. If the prosecution doesn't want to bring it, the statute allows the court to. And I appreciate then the court may very well have to do what the court did. You've argued constitutionality, you'll get to that. And I get that. But what, particularly beyond just acting as the person bringing the motion, which the judge was, what did the judge do, particularly that showed that they were unable to fairly assess the evidence in this case, other than just the general conduct? And fair enough, that's your argument, I get that.
I would say his conduct, and then being able to truly remain impartial when he's making these decisions. He is ruling on the defense's objections to his own evidence, so we'd argue that he was not impartial here. If we were not, the court had alternatives here. So if we were to say that our assignment 3 is that the revised code as written is unconstitutional. But if he had proceeded to just remain impartial and bring the motion, he could have appointed a special prosecutor in this scenario. And that would essentially eliminate any possibility of partiality. The
statute does not specifically allow for a special prosecutor, does it, as I recall?
No, but the court has an inherent power to appoint. So again, with this conflict of interest that the prosecutor did not feel like they could bring the motion, that is an alternative that the court had that would be able to remain impartial and still bring the motion under this particular statute. I will briefly mention that we argue that it is unconstitutional, the revised code under subsections B and C. 1, by allowing the judge and ultimate decision maker to intervene, violates the right to a true adversarial process. And 2, revised code 22CA011868 forces the judge into the role of investigator.
Counsel, I just want to let you know that you're moving into your rebuttal time.
Okay, thank you, Your Honor. I will just briefly conclude. For these reasons, we respectfully ask this court to reverse the juvenile's holdings and remand for further proceedings. Thank you.
Okay.
Good morning, judges. My name is Rick Raley. I'm appearing on behalf of the state of Ohio and Lorain County Prosecutor J. Tomlinson today. And I'm asking that you affirm the trial court's judgment. And before we move into the substance of the argument, I will address the waiver issue that's been raised. It is true that at the invocation hearing in this case, the state remained silent. I would not classify that as an agreement that there was not necessarily evidence in this case. There's also discussion by the trial prosecutor about the distinction between the probable cause standard and the clear and convincing standard. Essentially, the state's position was that we didn't want to put the cart before the horse because this young lady faced very serious charges in Cuyahoga County. For prudential reasons, the state would want that more serious case to go forward first, typically. And in my career, I've noticed that in most probation situations end that's why doing the invocation proceedings. However, the judge in this case particularly wanted this to go forward when he did, and the matter did go forward as it did. So my position today to you is really arguments about the statutes, about what occurred here, because I don't think that there's an overcoming of the presumption that the judge acted without bias in this case. And to just talk about the statutory authority that the trial court had. So with that, I would move into the first assignment of error about the statutory authority of the juvenile judge in this case. And really to start with this first issue about whether TM was on probation or not. I think that's pretty clear from the judgment entry. It said she shall be placed on probation. There was a no contact order issue, a no contact order issued against her, and a case plan was adopted.
Well, she was placed on probation to be supervised by Cuyahoga County, and kind of rejected that supervision. And this court didn't make any order saying who was supposed to supervise her. So clearly that order cannot be placed in effect, and never took effect, and Cuyahoga County said, no, thank you, we don't want to supervise this person.
So in my view, Judge, what happened, that judgment entry created the community control probation standards. The transfer issue is separate, and that has to go with administrative issues between two different counties. The court speaks through its judgment entries, and those judgment entries place conditions on her. So for instance, if she violated that no contact order the next day, it would be their position that she wasn't on probation, so it didn't matter. I don't think that's the way the law intends for this to work. We speak through judgment entries, and the judgment entries was clear in this matter. And then moving on to the clear and convincing evidence about the substantial risk to the community, I think the description of her confessing to a murder quite clearly shows that she's a risk to the community. That in itself.
Well, let me, one thing on this, in this point too, and let me just point out on page 19 on your footnote, you tell us about what happened in that case. That's nowhere in the record. The result of that is not included in the May hearing, is it?
No, it's not, Judge, and it could not.
I would caution you to give us evidence outside the record on appeal. We are limited, as you know, to the record before us.
I appreciate that, Judge. I put that down there just for full clarity and full disclosure to you. I was not using that as any substance in my motion.
Well, it begs the question, in the future case, if you don't put it down, is there some reason why you didn't tell us what happened in the case? So I would suggest you stay to what the record gives us and no more.
I appreciate that, Judge.
So,
The other things I would also like, point out that there is also evidence that she's unable to be rehabilitated based on that confession, based on that condition. Now, the rules of evidence do not apply to this proceeding, so there was hearsay, but that does not matter in my view.
well, doesn't it matter to the weight we give that, and whether it's clear and convincing when we're getting a hearsay statement from a purveyor in terms of saying, hey, someone else in my office talked to someone over here, and they told them this? I mean, how much weight should the judge put on that type of evidence?
So, if, for instance, if there had been some sort of cross-examination on that point, like, well, no, she didn't actually confess, or maybe, there's a right to subpoena witnesses as well, brought in and say, no, there was no confession, those would be important issues that would go to the weight, I would believe. But since it was really kind of uncontested that she made that confession, I think at this point the trial judge put weight on it, and I think that was appropriate. Now, moving on to the second and third assignment error, which I would, argue together a little bit.
Other than her criminal offenses,
Yes.
well, you can see there was no evidence that she was a substantial risk to the public. I mean, they talked about the fact that, I think you in your brief indicated that when there was evidence that she didn't do treatment and counseling and those types of things. And they point out that that was, at the sentencing hearing, that was talked about, and there was no evidence after she pled that she had still refused counseling. You concede that it's correct. After she pled, there was no evidence about her efforts to get counseling or anything else?
Yes, I would say that the state's position was that she wasn't able to be rehabilitated at the beginning. So I just wanted to put that there is evidence already that she was not a good candidate for rehabilitation. And I'm quite frankly shocked that Cuyahoga County said she was at low risk based on what I heard the description of what she's accused of doing and confessed to doing in Cuyahoga County.
And that was on the record in May that they had, the Cuyahoga County had said she was low risk.
I do not recall that. I'll accept counsel's representation today. It sounds as though it might have been from her attorney, which, it is what it is, but the rules of evidence don't apply, as I just mentioned. Now, the other thing that I would also say, I think that it would be a very wide-reaching result if this court were to say essentially that when a trial court brings its own motion that it's violating due process. That would implicate probation revocation throughout the state. I can think in Summit County, for instance, when I was practicing down there as a prosecutor, we did not file our own motions to revoke probation. Basically, a probation officer employed by the court put together a report, and we had a hearing on that report essentially. There's no authority for that proposition. I think it's something this court should abstain from going along with.
And it's concerning here that we have a court that must have done its own investigation. There's nothing in the record of how this got to us other than somehow the court investigated the matter itself and then made decisions. So we have the court acting as an investigator, calling witnesses, taking all these actions. Isn't that some concern on how this court in those circumstances can be partial?
I wouldn't say that the judge had acted as an investigator. What it sounds, and I think it's very common for any sort of revocation proceeding like this, is essentially probation report probation officer finds out that this occurred and brings it to the court's attention.
Is there evidence of that in the record?
I don't know it exactly, but I think it's pretty implicit from the fact that probation's officer there says, I have all these reports and I know this about her. Here's what I know, Judge, and this is what I learned from these reports. So I think that's very common throughout most of our courts in the state, and it's quite a precedent to set that that's a violation of the process, especially when the defendant's able to get notice of what they're accused of, what they're accused of to violate their probationary conditions. They're able to cross-examine, they're able to subpoena witnesses. Those are all the due process guarantees that they're given that were provided in this case, so I don't think it's a violation. If there's no further questions, I just ask you affirm the judgment of the trial court.
Just briefly, do you agree, in their reply brief, they indicate that you responded to the fact they argued Reagan Tokes for unconstitutionality. In their reply brief, they said, oh, we made a mistake. We wanted to assert that the trial counsel was ineffective for not arguing the constitutionality of the statute.
Right.
You accept that's a fair mistake and we should review it not under Reagan Tokes, but under the constitutionality for the ineffectiveness?
My only response to the Reagan Tokes issue is that it was not futile for the trial counsel not to bring up that issue. So I think it's appropriate for the court to review it.
Well, do you think it's futile for the trial court, the counsel in this case, to have argued the constitutionality?
Yes, because at that time, there was not a single, and there still is not a single opinion which has held that it is unconstitutional. There are some trial judges in Cuyahoga County, but they have been reversed by the 8th District on that issue. I don't think we should expect a trial lawyer that they're going to advance novel, unsupported interpretation of the law like that. Thank you, Your Honors.
Thank you. And you'll have 2 minutes and 41 seconds for your rebuttal.
Okay, thank you, Your Honor. I just wanted to clarify a couple points. The first being, specifically about the motion to suppress and the confessions. Again, these were the probation officer's statements. They were not even statements of his own. They were of his supervisee. They did not call to verify. Again, we would just have issues, and the trial counsel below did effectively argue that this was hearsay. The second point of clarification is in regards to the low risk to reoffend and whether or not that was in the record. So this was not presented by defense counsel. This was actually presented by the probation officer. And in this, TM had admitted to a singular misdemeanor count of unauthorized use of motor vehicle. This is on pages 9 and 10 of the transcripts. And again, because TM scored a low risk to reoffend, the juvenile Cuyahoga County Court did not see pertinent to put her on probation and gave her no dispositional orders. Again, that's on page 14 of the May 5th transcript. And in response to the placing TM versus actually serving, again, this is similar to if you were to, say, send someone to prison, but they were never actually picked up. They are not serving their sentence. Yes, this court placed her on probation, but again, she never met with someone, she never signed any rules, and in fact, it was actually denied later by an administrative judge in late December. And the last is, again, that these SYO indications cannot be treated the same as probation revocations for 3 reasons. 1, they serve entirely different purposes. 2, the standard of proof required for an indication is much higher than that of probation revocation hearings. They require substantial, here is clear and convincing. And last, the due process requirements for an indication hearing are vastly different than that of a
Didn't the
probation.
Supreme Court in In Re JV, I believe, look at, compare these somewhat to probation revocation hearings or those type of hearings? Just generally speaking, they're not exactly the same, just to the general viewpoint of they're similar enough to consider them.
So in our reply brief, we essentially argued that we cannot draw from In Re JV a general due process. This was specific to the evidence standard, and they did say clear and convincing, but here we are just making a general due process argument. And last, the due process requirements for an invocation hearing, again, are vastly different. We equate these more of a criminal case. Again, as an SYO, they are given special rights and protections as children. And for these reasons, they cannot be treated the same as probation revocations.
And you would say the process violation here is the fact you have the person bringing the motion being the person making the decision, so you don't have an impartial tribunal.
Yes, but we even went further in our third assignment, that again, before that was even brought, just to bring the motion, they would have to effectively investigate beforehand.
Okay, and counsel, I'm gonna have to ask you to wrap up, you're out of time.
Okay, again, just for these reasons, we respectfully ask to reverse the juvenile court's hearing and remand for further proceedings. Thank you.
Thank you. Thank you both for your presentations. We will take the matter under advisement and issue a decision in due course. The clerk of courts will mail that decision to you on the day that it is released, and the opinion will also be posted on the Ohio Supreme Court website. Thank you very much.